Welcome to our YouTube video series on legal terminology. In this particular video, we will be looking at the distinctions between punitive damages and aggravated damages. Now, to understand the distinction as between punitive damages and aggravated damages, we should look to the words of Supreme Court Justice McIntyre in the Supreme Court of Canada case, Vorvis versus Insurance Corporation of British Columbia, where he said, "It will be well to make clear the distinction between punitive and aggravated damages. For in the argument before us, and in some of the materials filed there, appears some confusion as to the distinction. Punitive damages, as the name would indicate, are designed to punish. In this they constitute an exception to the general common law rule that damages are designed to compensate the injured, not to punish the wrongdoer. Aggravated damages will frequently cover conduct which could also be the subject of punitive damages, but the role of aggravated damages remains compensatory. The distinction is clearly set out in Waddams, the laws of damages, in these words. An exception exists to the general rule that damages are compensatory. This is the case of an award made for the purpose not of compensating the plaintiff, but of punishing the defendant. Such awards have been called exemplary, vindictive, penal, punitive, aggravated, and retributory. But the expressions in common modern use to describe damages going beyond compensatory are exemplary and punitive damages. Exemplary was preferred by the House of Lords in Castle and Company Limited versus Broome. But punitive has also been used in many Canadian courts, including the Supreme Court of Canada in H.L. Weiss Forwarding Limited versus Omnis. The expression aggravated damages, though it has sometimes been used interchangeably with punitive or exemplary damages, has more frequently in recent times been contrasted with exemplary damages. In this contrasting sense, aggravated damages describes an award that aims at compensation, but takes full account of the intangible injuries, such as distress and humiliation, that may have been caused by the defendant's insulting behavior. The expressions vindictive, penal, and retributory have dropped out of common use. Aggravated damages are awarded to compensate for aggravated damage. As explained by Waddams, they take account of intangible injuries and by definition will generally augment damages assessed under the general rules relating to the assessment of damages. Aggravated damages are compensatory in nature and may only be awarded for that purpose. Punitive damages, on the other hand, are punitive in nature and may only be employed in circumstances where the conduct giving the cause for complaint is of such nature that it merits punishment. Some additional notes of Supreme Court Justice McIntyre on the concept of punitive damages were as follows. Problems arise for the common law whenever the concept of punitive damage is posed. The award of punitive damage requires that a civil court impose what is in effect a fine for conduct it finds worthy of punishment, and then to remit the fine not to the state treasury, but to the individual plaintiff who will, by definition, be overcompensated. Punitive damages are not recoverable for a breach of contract unless the conduct constituting the breach is also a tort for which punitive damages are recoverable. Punitive damages may only be awarded in respect of conduct which is of such nature as to be deserving of punishment because of its harsh, vindictive, reprehensible, and malicious nature. Thank you.